You are driving down a rural highway somewhere in Alberta. You have got your restricted firearms license. Your PAL is in your wallet. Your handgun is secured in a locked case in the back seat exactly the way the law requires. You are doing everything right. Then the lights come on behind you, routine stop, maybe a tail light, maybe nothing at all. The officer comes to your window, spots the case, or maybe he ran your plate and your license already flagged. And then he says it, hand me your gun. 4 words. And what you do in the next 5 seconds does not just determine whether you drive home tonight. In Canada, it determines whether you face a criminal firearms charge, whether your PAL gets suspended or revoked, and whether you end up in a system that is extraordinarily difficult to exit once it has your name in it. Because here is the truth that most licensed firearms owners in this country do not know. That command is not a simple request. It is a legal and physical crossroads with traps on every side. And the vast majority of people, good, law-abiding, licensed Canadians, get it completely wrong. Not because they are doing anything illegal, but because nobody ever told them what the law actually says, what the officer is actually doing, and what the exact words are that protect them in that moment. So that is what this video is. I am going to walk you through exactly what is happening when a Canadian officer says, hand me your gun. I am going to explain the specific legal framework in Canada that governs that moment, because it is profoundly different from what most people assume. I am going to give you the exact phrase to say back, word for word, that protects your rights, keeps you safe, and keeps the stop from turning into something far worse. And I am going to show you the follow-up traps that come after, because there are at least 2 of them. And one of them can strip your license permanently, even if you did everything right at the window. Before we get into it, there are 2 ways these situations go sideways in Canada. You say the wrong thing under pressure, and it becomes part of an investigation you never anticipated. Or you try to assert rights you think you have, but that the Canadian legal system does not actually recognize the same way you think it does, and that turns a cooperative stop into a confrontational arrest. Both outcomes are avoidable. Both of them start with understanding what you are actually dealing with. The moment that officer says those 4 words, here is what you need to understand first. And this is the foundation everything else is built on. Canada is not the United States. The legal architecture around civilian firearms in this country is fundamentally different, and the rights a licensed carrier has during a police encounter are governed by an entirely different set of laws, court decisions, and constitutional provisions. The Canadian Charter of Rights and Freedoms is not the American Bill of Rights. Section 8 of the Charter protects you against unreasonable search and seizure, and Section 9 protects you against arbitrary detention. Those are real rights. They have real force. But the way they operate in a roadside firearms encounter is far more nuanced than most people realize. And assuming your rights work the same way they do in an American YouTube video you watched last week is one of the fastest ways to make your situation dramatically worse. Now let us talk about what that officer is actually doing when he says, hand me your gun. He is not being casual. He is running a protocol that he was trained to run the moment a firearm entered the picture. He does not know you. He does not know if your license is current, if the firearm is stored correctly, if it is loaded, or what your intentions are. From his perspective, the safest immediate outcome is to get that firearm out of the equation while he figures out what he is dealing with. And in Canada, his legal authority to do that is actually quite broad, and it comes from places that will surprise you. Under the Criminal Code of Canada, Specifically, Section 117.02. A peace officer who has reasonable grounds to believe that a firearm is present and that it poses a risk to public safety has the authority to search for and seize that firearm without a warrant. That is a very wide door. And unlike the American Terry stop framework, which requires at minimum a reasonable suspicion that a crime is being committed, the Canadian threshold is tied to a safety concern, which is a more flexible standard and one that a well-trained officer can articulate quite easily in the context of a traffic stop where a firearm has just entered the picture. On top of Section 117.02, you have got the general powers of search incident to detention, which Canadian courts have interpreted broadly under the Charter. The Supreme Court of Canada in Arver's Mann established that police can conduct a pat-down search of a detained individual where they have reasonable grounds to believe that their safety or the safety of others is at risk. And in RV, Safford, and a number of provincial appellate decisions since then, courts have consistently held that the presence of a firearm, even a legally possessed and properly stored one, can satisfy that threshold in the context of a roadside stop. So here is the reality you are standing in at that window. The officer very likely has the legal authority to secure your firearm for the duration of the stop. Not because you are a criminal, not because you have done anything wrong, but because Canadian firearms law gives significant latitude to officers managing safety risks in the field, and a loaded or accessible firearm during a traffic stop qualifies. Fighting him on whether he gets to hold the gun is a battle you have already lost before the first word leaves your mouth. The law handed him that fight on a silver platter. But here is where it gets critically important, and this is the part that almost nobody tells you. The legal fight you can actually win, the one that protects your pal, protects your record, and protects your long-term rights as a firearms owner in Canada, is not about whether he takes the gun. It is about how that gun leaves your hands, what you say in the process, and what you refuse to consent to afterward. Now let us look at the storage and transport rules. Because in Canada, this is where most licensed owners unknowingly walk themselves into charges before the officer even finishes his sentence. Under the storage, display, transportation, and handling of firearms by individuals regulations, a restricted firearm being transported must be unloaded in a locked container, and in many cases must be transported directly to one of a small number of authorized destinations. A prohibited firearm has even stricter requirements. The officer knows this. When he sees a firearm case or when your plate flags a restricted license, one of the first things running through his mind is whether the storage and transport conditions are compliant. And if they are not, that is not a minor administrative issue in Canada. That is a criminal offense under Section 86 of the Criminal Code, unsafe storage of a firearm, which carries a maximum penalty of 2 years imprisonment. This means that before you say a single word about the firearm, you need to understand that anything you say about it, any explanation you volunteer about how it is stored, where you are taking it, or why you have it with you, is potentially being evaluated against those regulatory requirements. You are not just having a conversation. You are potentially giving evidence. Now, let us walk through the doors that most people open, because every one of them creates a different kind of problem. The first door, you want to be cooperative. You are a legal owner. You have nothing to hide. So when the officer says, "Hand me your gun," you say, "Sure, no problem," and you reach for it. That cooperative instinct, that desire to show you are one of the good guys, is one of the most dangerous things you can do in that moment. An officer watching you reach toward a firearm during a traffic stop does not see a helpful citizen. He sees an unpredictable threat developing in real time. He cannot read your intentions. He can only read your movements. And your hand moving toward a weapon is the movement he is trained to fear most. The second door, you know your rights. You have done your research. So when he asks for the gun, you say, I am fully licensed. You have no right to take my property. I understand the impulse completely. But exercising your rights on the side of a road in Canada is not the same as having your rights respected. You do not win a charter argument at a car window. You win it later in front of a judge with a lawyer beside you and a recording of you being calm and cooperative as your evidence. The roadside is not the courtroom. Treating it like one will make everything worse. The third door, you say nothing, you freeze, you hope the moment passes. In Canada, there is no universal duty to disclose that you are carrying in the way some American states have. But silence that looks evasive to an officer who already knows or suspects there is a firearm in the vehicle can escalate the stop very quickly. And if he finds the firearm himself rather than learning about it from you, the dynamic of that stop changes fundamentally and not in your favor. Each of those three doors leads somewhere worse than where you started. So let me give you the door that does not. Here are the exact words. Memorize them. Write them on a card and put it in your glove box if you have to, because under pressure, your brain will not write new material. The moment the officer's attention moves toward the firearm, before he finishes his sentence, if you can, you say this calmly and evenly. Officer, I want to be fully cooperative. I have a valid PAL, and the firearm is stored in a locked case in the back. My hands are on the wheel, and they are staying there. Tell me exactly how you want to handle this. Now, let me break down why every single element of that phrase is doing a specific job. I want to be fully cooperative. You are establishing your posture before anything else. You are signaling that this is not going to be a confrontation. That matters enormously for how the next few minutes unfold, both for your immediate safety and for how any report of this stop is written afterward. I have a valid PAL, and the firearm is stored in a locked case in the back. You are giving him two critical pieces of information. First, that you are a licensed individual, which immediately lowers his threat assessment. Second, that the firearm is in the back, not at your hip, not under the seat beside you, not within immediate reach. Distance from the firearm matters legally and physically in this moment. Notice also that you are saying where it is and describing the storage condition. You are not shouting, I have a gun. If there is a partner officer on the passenger side, all that partner hears is the word gun, and a chaotic stop becomes a dangerous one very fast. Be specific, be calm, skip the drama. My hands are on the wheel, and they are staying there. This is the line that keeps you physically safe. You are making explicit that you will not reach for the firearm no matter what. You are rejecting door number one out loud on the record before he even has to worry about it. Even if he subsequently asks you to retrieve the firearm yourself, you do not move your hands toward it. Not yet. Not without a very clear plan established between you. Tell me exactly how you want to handle this. This is the line that protects your legal position. You are returning the decision-making authority to him, which the law already gave him anyway. You are not conceding anything. You are not consenting to a search. You are simply acknowledging that he directs and you follow lawful instructions. That framing matters because it means nothing that happens next can easily be characterized as voluntary consent to something broader than you intended. Now let us talk about what happens when he pushes back, because in Canada, he very well might. He might say, just reach back and grab it for me. And here is where people panic and make a catastrophic mistake, either by reaching for it or by refusing in a way that sounds defiant. Neither of those is the right answer. The right answer is this: Officer, I am not comfortable unholstering or retrieving the firearm while I am seated and you are standing this close. I am happy to step out of the vehicle so we can do this in whatever way you think is safest. I will follow your lead completely. You are not refusing a lawful order. That would be a criminal offense under Section 129 of the Criminal Code, obstructing or resisting a peace officer. You are expressing a safety concern about a specific physical motion and offering an alternative that serves his safety interests as much as yours. Most officers will respond well to that. If he orders you out of the vehicle, you get out immediately, without argument, without commentary, with your hands visible and your movement slow and deliberate. That is his lawful authority, and you exercise none of yours by arguing with it on the side of the road. Now, here comes the second trap, and this is the one that catches people right after they think the hard part is over. Once he has secured the firearm, once the tension has dropped, and everybody is breathing again, he may say something like, while I have got you here, I am just going to take a quick look through the vehicle. And it will sound casual. It will sound routine. It might even sound like he is doing you a favor by handling it informally. That is the moment you say quietly and clearly, I do not consent to any searches. That is it. Those 6 words. You do not explain why. You do not apologize for saying it. You do not offer a compromise. You say it once, clearly enough for any dash camera or body camera to pick up, and then you stop talking. In Canada, a general search of your vehicle requires either a warrant, your consent, or a recognized common law or statutory exception. The fact that you have a firearm in the vehicle does not automatically create a search exception for the rest of your belongings. RV. Caslake, at the Supreme Court level, and numerous subsequent decisions have confirmed that a search incident to arrest or detention must be connected to the reason for the stop, not a fishing expedition for unrelated evidence. If he searches anyway after you have refused consent, that is a potential Charter Section 8 violation, and everything he finds may be excludable at trial under Section 242. But you do not win that argument at the window. You create the record at the window, and you win the argument later in a courtroom. Say the words, say them once, and then cooperate fully with everything else he asks. That is a lawful direction. That distinction between consenting to a search and complying with lawful directions is one of the most important distinctions in Canadian civil liberties law, and one of the least understood by ordinary people on the side of the road. Now let us talk about the third trap, the one specific to Canada that has ended the firearms careers of people who did absolutely everything else right. After the stop is over, after he has returned your firearm or made other arrangements, there may be a follow-up administrative process. In Canada, a police officer who believes on reasonable grounds that a person possesses a firearm or ammunition in a way that poses a risk to the safety of any person can apply to a provincial court judge for an order authorizing the seizure of that person's firearms, ammunition, and licenses. This is called a Section 111 peace bond application, and it can be triggered by something as simple as an officer noting in his report that you seem nervous, that your answers were inconsistent or that the interaction felt concerning to him. You cannot control whether he makes that application, but you can absolutely influence the content of his report by how you behave during the stop. An interaction where you were calm, cooperative, clearly knowledgeable about your legal obligations, kept your hands visible, offered safety-conscious alternatives to potentially dangerous movements, and clearly and politely declined to consent to a broader search is an interaction that reads very differently in a police report than one where you were agitated, argumentative, or evasive. This stop was never really about whether your gun is legal. It was always about whether you look safe, whether you sound reasonable, and whether you give the officer any reason to characterize the encounter as concerning in ways that follow you long after you drive away. There is one more thing worth knowing, and even many Canadian criminal lawyers are not as clear on this as they should be. Your possession and acquisition license, your PAL, is not just a document. It is a continuing authorization that is subject to ongoing review. Under Section 67 of the Firearms Act, a chief firearms officer can revoke a license if they have reasonable grounds to believe that the holder is no longer the kind of person in respect of whom a license should not be refused. That is a remarkably low threshold. And a police report noting concerning behavior during a firearm stop can absolutely trigger a CFO review. The practical implication of this is that how you handle that 5-minute traffic stop has consequences that can extend years into the future. Your PAL, your ability to own, acquire, and transport firearms legally in Canada, is potentially on the line in that conversation at the window. Not because you did anything wrong, but because the legal framework gives considerable discretionary authority to both police and CFOs, and your behavior during enforcement encounters is part of the record those authorities can draw on. That is why the exact words matter so much. Not just for your immediate safety, not just for avoiding a charge on that specific night, but for protecting the legal status you have worked to obtain and maintain as a responsible, law-abiding firearms owner in Canada. So let me bring it all together simply. When a Canadian officer says, "Hand me your gun," the worst things you can do are reach for it immediately, argue about your rights confrontationally, or say nothing and hope it passes. The right answer is calm, clear, specific, and legally protective. You tell him you are cooperative. You tell him your PAL is valid. You tell him where the firearm is and how it is stored. You tell him your hands are on the wheel and are staying there. And you ask him to direct you on how to handle it safely. If he orders you out of the car, you get out. If he wants to secure the firearm, you let him, because the law gives him that authority and fighting it makes everything worse. If he asks to search the vehicle, you say clearly that you do not consent, and then you let your lawyer win that argument later, where arguments like that can actually be won. Steady words, still hands, no surprises. That is how a forward command that has destroyed the lives of otherwise law-abiding Canadian gun owners becomes the most forgettable stop of both your evenings. Keep your hands visible, keep your voice calm, know your phrase before you ever need it, and you give yourself the best possible outcome in a situation where the stakes could not be higher. One more thing that separates the Canadian context from anything you may have seen in American firearms content online, and this is genuinely important. Canada does not have a nationwide duty to inform law the way some American states do, where you are legally required to proactively disclose that you are carrying the moment an officer approaches. In Canada, there is no single federal statute that creates a blanket obligation to volunteer that information unprompted. However, and this is where people make a very costly assumption, the absence of a duty to proactively inform is not the same as having a right to actively conceal. If an officer directly asks you whether you have any firearms in the vehicle, lying to him is obstruction. Saying nothing when he has already clearly seen the case or when he is asking a direct question is a very different legal situation from simply not volunteering the information before he asks. The distinction between silence and active deception is one that Canadian courts take seriously, and you need to take it seriously too. There is also a provincial dimension to this that catches people off guard, particularly if you drive across provincial lines. While firearms regulation is primarily federal in Canada under the Criminal Code and the Firearms Act, provincial highway traffic legislation and provincial police services can create slightly different enforcement environments. An RCMP officer in rural Saskatchewan approaches a firearms stop somewhat differently in culture and training than a Toronto Police Service officer in an urban context, even though the underlying law is the same. The procedural expectations, the tone, the immediate assumptions about why someone has a restricted firearm in their vehicle, all of these vary by jurisdiction and by context. The legal framework is national. The human reality of the encounter is local. And knowing that helps you calibrate your tone and your approach without in any way changing the legal fundamentals of what you say and what you refuse to consent to. The bottom line is this. When you hear those 4 words, "hand me your gun," from a Canadian officer, you are not at a crossroads between cooperating and asserting your rights. You are at a crossroads between protecting yourself intelligently and destroying yourself accidentally. The officer has significant legal authority. You have real charter protections. And the way you navigate that 5-minute window determines which of those 2 things ends up mattering more in the days, months, and years that follow. Know the phrase, know the follow-up lines, know what consent means, and why you never give it casually, and understand that how you behave in this encounter is part of a record that extends far beyond the moment those blue lights go dark and you pull back onto the road.